Thank you. Ladies and gentlemen, could I first of all express my thanks to the Institute for Cultural Diplomacy for inviting me to this event to speak on the issue of the Convention on the Prevention and Punishment of the Crime of Genocide. Maybe in a broader way, but trying to focus on some of the aspects. I also wanted at the outset to pay tribute to the work and thinking of Raphael Lemkin, a Polish attorney and scholar who successfully campaigned for the implementation of laws defining and forbidding genocide in international law. And Yanis, my colleagues, have given you some other details I can now put aside. Yanis also was so kind to give you an insight into the content of the Genocide Convention. And he spoke about the definition. I think the definition as it is contained in the UN Convention on Genocide is a very important one. But as he said, this definition is leaving aside the issue of cultural genocide, the issue of ethnic cleansing, and also the issue of genocide of political groups. Another key article in this convention is Article 6, which says that genocide will be punished either by a competent tribunal of the territorial state or by, and I quote, such international penal tribunal as may have jurisdiction. Now, what could be said about the strength and the weaknesses of this convention? And Giannis also has spoken about this some minutes ago. Paola Gaeta, who is professor for international criminal law, has written a book entitled UN Genocide Convention. She starts this book by saying that, and I quote, 60 years have elapsed since the adoption of the convention, which marked a monumental moment in contemporary public international law, laying the foundation for a new common ethos, uniting the international community following the tumultuous and divisive events of the Second World War. Yet, despite this momentous breakthrough, it proved to be somewhat of a false dawn, as the Genocide Convention, as a legal instrument, remained somewhat dormant for 40 years. It was not until the tragedies of Rwanda and Yugoslavia in the 1990s that courts, both at the international and national level, began to apply the convention. For Professor Gaeta, there is and I quote, there is a huge gap between the rhetoric of the objectives enunciated in the preamble of the convention, liberate mankind from the egregious practice of genocide, and the means effectively envisaged by the convention itself to achieve such objectives. She adds that this comes as no surprise, as the Genocide Convention comes into direct confrontation with state sovereignty, as it looks to criminalize acts which have historically been committed in furtherance of state policies. An effective mechanism for the prevention and punishment of genocide could have only been established if states were ready to surrender large portions of their sovereignty, something that states were as resistant to do back then as they are today. The outcome is a legal text whose strength lies more in its moral breadth than in the content and stringency to its legal obligations. The weaknesses of the convention itself could be summarized as follows. First, it focuses more on punishment than on prevention, by simply imposing punishment rather than adopting preventive measures. Two, it does not clearly intend to apply to acts of genocide committed by states as such. It focuses merely on genocide as a crime committed by individuals and entailing their personal criminal accountability. Three, it excessively relies on the territorial state that is a state in whose territory the genocide has taken place. And 4, there is an absence of any monitoring mechanism, unlike most of the other main human rights treaties. The modest and vague nature of some of the Convention's key provisions has cast doubts on its ability to effectively prevent and punish acts of genocide. However, thanks to acts of interpretation and other related legal developments, the international prohibition against genocide is today much more comprehensive and robust than the prohibition introduced by the text of the Convention, and it was understood in 1948. Professor Gaeta adds that, and I quote, "International law now does contain a comprehensive legal prohibition against genocide, which applies at both the state and individual level, with increasingly sophisticated means of legal enforcement. Yet the real challenge ahead of us appears to be the same than confronted Lemkin's contemporaries: the need for stronger political will at the international level that could underlie a robust and prompt response to genocide," unquote. Gareth Evans, former Foreign Minister of Australia, stresses that, and I quote, "It took the major powers years, and in the case of the United States, it was said already 40 years, to ratify the Convention. It was rarely invoked and has never been effectively applied in practice, either to prevent or punish actual atrocities." One example to show that: the long-awaited test case in the International Court of Justice, Bosnia versus Serbia, decided that Serbia had not itself committed genocide in Srebrenica, though it did have some culpability for failing to prevent it. But no compensation or reparation was to be paid, and in its ruling, the court simply decided that Serbia shall immediately take effective steps to ensure full compliance with its obligations to punish genocide and to transfer individuals accused of genocide to the International Criminal Tribunal for the former Yugoslavia. For Gareth Evans, this case showed too clearly that what lawyers had long feared, namely that the legal definition of genocide, as provided in the Genocide Convention, is so narrow in scope that there are very few kinds of behavior by either individuals or governments that will be actually caught by it. Gareth Evans sees mainly 3 explanations for the weaknesses of the Convention, noting that even the Cambodian killing fields were not seen of being of any of the world's business. The first factor goes back to the Peace of Westphalia in 1648, namely that what sovereignty means above all else, control of a state's territory, unfettered by external constraints. This remained an incredibly tenacious belief in the minds of the UN key players. Article 2, paragraph 7 of the UN Charter states namely that, and I quote, nothing contained in the present Charter shall authorize the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state." A second factor was the large increase in UN membership during the decolonization era, which reinforced this very traditional view of sovereignty. Between 1945 and 1989, UN membership grew from the original 51 member states in 45 to 159 in 89. And the states that joined were mostly developing countries. And these developing countries were, of course, keen that there would be no new intervention, as they have known it during the colonial time. The third factor is related, according to Evans, to the dynamics of the Cold War, which dominated the UN system almost from the start and hamstringing the organization when it came to dealing with mass atrocities. The 2 major superpowers rapidly became very focused on what was needed to keep their respective alliances blocs functioning, and were reluctant to impose any significant constraints on misbehaving partners. All this meant that during this period of Cold War, a great many serious crimes against humanity were perpetrated, either actively by states or in the face of their unwillingness or inability to intervene without any effective action being taken or even attempted by any outside power. Gareth Evans has a list of some 10 of these genocides which have been committed during the Cold War, starting with the Indonesian massacre of up to 500,000 or more Communist Party members, suspected sympathizers from 1965 to 1966. I'm skipping the rest of the list because it would be too long. What I'm arguing is that two of the three factors Gareth Evans is mentioning continue to apply even after the Cold War. The fact is namely that atrocities, massacres, and genocide of unbelievable scale did occur in the years after the fall of the Berlin Wall. The worst case is probably the Rwandan genocide, where some 800,000 people were killed. Second, 5 million people were killed in the Great Lakes region in the 90s and early 2000s, mainly in the eastern part of the Democratic Republic of Congo. In Asia, Indonesia's rule over East Timor came to an end in 1999, amidst an orgy of violence that left thousands dead. The Balkan War in the 1990s killed 250,000 and gave the world a new phrase, ethnic cleansing. 7,500 died in the Srebrenica massacre. Darfur is another example of horrendous violence and terror which left some 250,000 dead and forced more than 2 million to flee. What could be done to improve the situation? Possible remedies. Professor Gaeta admits that, and I quote her, to eradicate an odious practice such as that of genocide, there is still a long way to go, with many battles yet to be fought. However, one should not forget that in life, as in law, progress is often made incrementally, step by step. With 60 years having passed, efforts should be undertaken which would help in strengthening the legal regime and help give substance to the rhetoric of genocide eradication. One significant step, tangible step, is a possibility of filing the Genocide Convention with an international supervisory body, modeled upon the Committee Against Torture. This body should be competent to receive and examine regular reports by states parties on how the provisions of the Genocide Convention are implemented. The possibility should also be explored of giving this international body the task, under exceptional circumstances, to undertake inquiries and to receive interstate complaints. Other steps could include granting courts extraterritorial jurisdiction over genocide, entrusting the High Commissioner for Human Rights with the task of collecting national reports on the implementation of the Convention, disseminating information on the matter, and preparing model legislation for national implementation of the Convention. I have here another part in my intervention about new developments, where I also I'm talking about the tribunals which have been created in the 90s for former Yugoslavia, Rwanda, and the Rome Statute that Giannis already has dealt with, so I can also continue outside. My next paragraph, my next chapter here, responsibility to protect. On the occasion of the last March session of the Human Rights Council, 56 states made a joint statement on the responsibility to protect. It was mainly triggered by the events in the Arab world, including in Libya. In 2005, says this statement, the world leaders declared with one voice that the international community should never again countenance indifference in the fate of genocide, war crimes, ethnic cleansing, and crimes against humanity. They committed, as set out in the paragraphs 138 and 139 of the World Summit Outcome document, to the responsibility to protect. The summit outcome made clear that each individual state has the responsibility to protect its population from genocide, war crimes, ethnic cleansing, and crimes against humanity. It also clearly indicates that the international community should, as appropriate, encourage and help states to exercise this responsibility and support the United Nations in establishing an early warning capability. The leaders committed themselves as necessary and appropriate to helping states build capacity to, quote, protect their population from genocide, war crimes, ethnic cleansing, and crimes against humanity, and to assisting those which are under stress before crises and conflicts break out, unquote. For the authors of the book, I quote, UN Ideas Which Changed the World, unquote, perhaps the most dramatic innovation of the UN in the last few years is the idea of the responsibility to protect. No idea, they say, has moved faster in the international arena of norms, what is now commonly referred to as R2P. Indeed, the responsibility to protect is the title of the 2001 report of the International Commission on Intervention and State Sovereignty, an impressive example of a new action in the UN, a third UN action, as they say. The basic idea behind this doctrine is that human beings can count for more than the sacrosanct sovereignty enshrined in Article 2 of the Charter, which emphasizes non-interference in domestic affairs. The Commission grew directly from the inability of the Security Council to act in two particular instances: the mass murders in Rwanda in 1994 and the Kosovo disaster in 1999. The former resulted in action that was too little and too late to halt 800,000 deaths in a matter of weeks, and the latter in the view of many in too much action too soon when NATO began its humanitarian bombing without Security Council approval, unquote. The final text of the World Summit Outcome document of 2005 reaffirmed the primary role of states to protect their own citizens and encouraged international assistance so weak states could exercise this responsibility. At the same time, it also made clear that international intervention is needed when countries fail to shield their citizens from, or more likely, actively sponsor genocide and other mass atrocity crimes, unquote. Normative advance, they continue, does not necessarily mean action, as the 300,000 dead and 3 million displaced in Darfur demonstrate. But a norm is emerging, with considerable state praxis behind it that articulates a collective international responsibility to protect human beings whose governments refuse to do so or are actually the cause of murder and ethnic cleansing. Shortcomings abound, they agree. The political will to support the new idea remains problematic. However, that military force used with international approval for human protection remains a policy option at all, represents a significant new middle ground in international relations. We should not expect instant results when such momentous normative change threatens the very foundation of the Westphalian Order and indeed of the United Nations. However, both the first and second UNs have been central to the emerging norm that sovereignty does not imply a license to kill. And the most recent normative push came from this third UN in the form of the International Commission on Intervention and State Sovereignty. Preventive measures. There is a long list of measures, mainly of a political and security nature, which have been developed in the 1990s with the aim to create a kind of prevention culture at the UN, which the Commission has strongly encouraged to expand. These measures include an early warning system, preventive diplomacy, ending impunity through the setting up of international criminal courts, and preventive deployments. The joint statement of the Human Rights Council reminds of the commitments taken by the World Summit and encourages the Council to support its practical implementation and cooperation with High Commissioner for Human Rights. It refers to the following measures: institution building, strengthening the rule of law, technical cooperation to promote respect for human rights and to prevent and address human rights violations, working with states to help build capacities and share best practices that reduce social tensions and contribute to conflict prevention. It also reaffirms support for the mandates of the special advisors to the Secretary General on the prevention of genocide and on the responsibility to protect. No doubt that human rights education and training would be an indispensable part of such an agenda and for the furthering of dialogue and tolerance among all human beings within countries and between countries, and for the furtherance of a kind of universal citizenship. Economic threats. The 2005 World Summit Outcome document asserts that development, peace and security and human rights are interrelated and mutually reinforcing. Development cannot be achieved without security, and security cannot be guaranteed without development. So for Gareth Evans, there is every reason from a conflict and mass atrocity perspective to take a major effort to dramatically close the income and opportunity gap between rich and poor countries, and to dramatically reduce levels of both absolute and relative deprivation. Achieving the Millennium Development Goals is not just a humanitarian aspiration, but a rational security as well, says Gareth Evans. Can we Europeans, I'm asking, help to solve, in the long run, the security, political stability, and migration issues in our relations with African countries without focusing more on development? For Alex Bellamy, Professor for International Security, there is a clear linkage between income, regime type, and mass atrocities. He adds that if the goal really is to end mass atrocity crimes once and for all, then economic development and democratization need to be a significant part of the agenda. Juan Somavia, General Director of the International Labour Organization, questions, and I quote, why it seems it is more urgent for the United Nations to act when someone is killed by a bullet than when someone dies of malnutrition, unquote. The fact remains that every day, 25 people, mainly children, die out of hunger and malnutrition. That means over 9 million every year. All these deaths are preventable. This is also a massive, violent, and flagrant violation of basic human rights, such as the right to life and the right to food. According to the Millennium Development Goal number 1, the portion of those suffering from hunger and malnutrition, some 840 million in the year 2000, should be reduced by half until 2015. End of 2009, this number not only was not reduced at all, but had increased and had reached the figure of 1 billion. In a book which Donald was so kind to mention and I have written on the issue, I am showing indeed that the policies put into place by major international financial institutions and by major world powers have a direct responsibility in regard to this situation, including through the structural adjustment programs which developing countries were urged to adopt and to implement, and which did hurt especially the rural poor. This also includes the liberalization of markets of these countries, despite their obvious difficulty to face international competition at the present stage of their development. Philip Alston, international law scholar, has suggested that the adoption of the Millennium Development Goals, including the one to eradicate extreme poverty and hunger, must be taken to have legal significance. And according to Andrew Clapham, Professor for International Law, I quote, the legal thinking on the customary international law obligations of international organizations is still rather nascent, but any meaningful project to ensure the prevention of atrocities has to focus on the preconditions for violence. And the International Commission stressed prevention throughout its report, even including a chapter entitled The Responsibility to Prevent. In this context, Andrew Clapham adds, more work needs to be done on the legal responsibility of non-state actors such as the World Bank and the International Monetary Fund, unquote. Who would deny that transnational corporations are also playing a major role in the work of globalization, but whose rights and obligations are not always well defined? For Andrew Clapham, a separate set of non-state actors with emerging legal responsibilities are corporations. I'm finishing with 2-3 remarks on the genocide in Rwanda. Romeo Dallaire was commander of the UN peacekeeping force at the time the 1994 genocide occurred. In his book, I quote, Shake Hands with the Devil, The Failure of Humanity in Rwanda, unquote, he explains the unspeakable disappointment he was experiencing during that time, and he concludes as follows. What I finally became aware of is that at its source of all that is a fundamental indifference of the international community towards a critical situation of 7 or 8 million black Africans in a tiny country without any strategic and without any natural resources susceptible to interest any world power, unquote. How could it happen that civil war in Rwanda led to such extreme consequences, and how is it to be explained that Tutsis and Hutus were attempting to exterminate each other? It has often not been acknowledged that these two groups were during long periods of their history living together rather peacefully, and that these two groups didn't even assume that they would belong to two different ethnic groups. The question was raised whether this tribal classification of two groups was not promoted through the policies implemented by the Belgian colonial rulers and in the exercise of their power by relying alternatively on one group against the other. Another idea. In his book entitled Globalization of Poverty and the New International Order, Michael Szosudowski, professor of economics, argues that before the genocide broke out in Rwanda in 1994, there was a kind of economic genocide caused by the structural adjustment programs the media did seldom mention. And he adds that a restructuring of agriculture, the steep fall of coffee prices, which represent 80% of its foreign earnings, and the imposition of macroeconomic reforms by the Bretton Woods institutions have severely impacted on the daily lives, worsening ethnic tensions and thus contributing to the political crisis. A last idea, and I have finished. Setting up a standing rapid deployment force. For Andrew Clapham, the paradigmatic case of Rwanda was not really about the lack of legal options or an issue of failing to call it genocide in time. The problem was about a lack of political will to save others. Whether or not there is a public appetite for more robust action from their governments, and whether or not this represents a democratic challenge to those arguing for a greater sense of responsibility to protect, it is suggested that the solution is tackle the lack of political will in times of crisis by building capacity to protect. Building capacity to protect. The proper solution must lie in new international arrangements that allow the international community to react with a standing rapid deployment force to protect those in imminent danger. If the Security Council, the General Assembly, or the Secretary General could call on such a truly multinational force, governments might be less hesitant about committing to taking robust action. In fact, the mere existence of such a standby force may go some way to fulfilling the responsibility to prevent, unquote. I couldn't agree more. I think the time has come to put into place such a standing rapid deployment force. I think it would only not have a clear operational dimension. I think it would also fulfill a very important, significant preventive purpose. Thank you so much.